You're gonna walk in like, you know, I'll be there. You want?
Yes, I think that's right.
You go to bed. To what?
Let's wait.
He's going next, and I want to tell you something really funny. Oh,
Okay. Are you folks ready?
As soon as Mr. Merritt's here, yes, Judge.
This is the time set for hearing on motion for deposition, State versus Leslie Merritt, CR 2015-144-211. Appearances, please.
Good morning, Your Honor. Vanessa Lateef on behalf of the state.
Good morning.
Good morning, Your Honor. Jason Lamb and Ulysses Farragut on behalf of Mr. Merritt, who is now present in custody.
Good morning. I read the motion for the deposition for the director and the state's response. We'll seek a couple of questions. Does DPS follow the normal practice where the case is assigned to DR?
Yes.
And there's a case agent assigned to be the clearinghouse for all investigative information?
For the most part, there was multiple investigations going on originally, but yes, there was one case agent eventually assigned.
Would it funnel through him whether there are any of the information that was mentioned in the pleadings apparently quoted by the director?
Any information with respect to the investigation would have been funneled through investigators to the extent that the statements made by Director Milstead to the media are accurate. I am unaware because I was obviously not part of the investigatory phase of the case.
Well, do you know, did the office make a search? If any such evidence exists, it's been disclosed. Is that fair to say?
Yes, Your Honor.
Mr. Lamb, Mr. Farragut, Mr. Lamb, I read your pleadings. Anything you want to add to your pleadings?
Judge, as a prefatory matter, I think the greatest focus of concern right now is the fact that what we'll call the fourth shooting has a changing timeline. The victim said it happened on August 30th, about 9:30 p.m. He said that, in fact, in 2 interviews, and now DPS has shifted that, and Colonel Milstead, at the microphone, said, no, it happened between the 22nd and the 27th. There is not a single piece of evidence that suggests that it actually happened between the 22nd and the 27th. Now, in the state's written response, they say that all evidence pertaining to the timeline can be discovered in the interviews of investigators or in the departmental reports. And the court inquired just a moment ago about whether the case agent would be the funnel point, if you would, for such information. Judge, there is no mention of the changing timeline in the departmental reports. There is nothing to suggest why this timeline was shifted, other than the fact that the gun was already in the pawn shop, making the ballistic match a factual impossibility. So that's a huge issue that we're dealing with. We also know that Director Milstead talked about the fact on a KTAR interview, which we provided you a link in the motion, where he talked about ADOT footage being reviewed. Well, the state has affirmatively stated that there is no ADOT video. And a moment ago, I just heard Ms. Lasico say that she didn't know if the statements that Colonel Milstead made to the media are accurate. And I appreciate that because she wasn't part of the investigation. But when you have the DPS director making an affirmative statement about the existence of evidence, and then the county attorney's office saying, well, that evidence actually doesn't exist, there is a material need for the defense to inquire into it. Now, he made some other statements as well about trajectories being looked at and analyzed. That was only done on one of the 4 shootings. Again, we want to probe into this, and this is a situation where, because he's making an affirmative statement about the existence of information that, according to departmental reports, does not exist.
The state has listed witnesses. The colonel's not one of the list.
But we have listed him.
Then the state presents evidence, and you have a position that there's absence of evidence. You can make that claim whether the colonel testifies or not.
I disagree, Judge, because effectively, if the state is suggesting that this evidence, the ADOT video and whatnot, bless you, does not exist, well, then Colonel Milstead would be impeaching the investigators. Then he is a witness whom we wish to call to impeach the case agent, who I might add is now retired from the Department of Public Safety, and other investigators, because there is no mention of this critical information. And as I indicated in my initial pleading, there are other matters. We would wish to present them in a sealed proffer so as not to compromise our work product.
Ms. Lasico, Ms. State, the defense now proffers as an material impeachment witness. What's your position on that?
Your Honor, I completely disagree. I believe that this is akin to the situation when defendant requested a deposition of Governor Ducey. At that time, the court specifically told defense counsel that they can work from the bottom up. That has not happened in this case. In fact, the defendant has only requested specific interviews of certain people. He has not requested interviews of any of the actual investigators on the case, which would be the case agent who is still available, former Trooper Beraldi, the current case agent, Trooper Bircher, who defense counsel has met with during other proceedings, but has never requested an interview. The individual who did the trajectory of the bus, Trooper Lamb, he, L-A-M-B, no relation, he too has not been requested to be interviewed by the defendant. Again, this is a situation where the defendant is jumping from A to Z without going through the rest of the alphabet. The state does not believe that Director Milstead has any material or necessary evidence pertaining to the investigation or the prosecution of the case. And we would ask that because of that...
Let me ask, is that based upon the case agent or talking with the colonel?
It is based upon all of the investigators involved in the case. And whoever the filter was, and I believe it went through Sergeant Knapp, who is also listed as a witness in this case, the information that Colonel Milstead received was based upon the people who are doing the actual investigation.
Who's been listed and are subject to 15-1 interviews or 15-3 depositions.
That is correct.
Mr. Lamb.
And Judge, the issue that we have is the state shouldn't be able to dictate the manner in which we do our due diligence. I don't necessarily want to depose certain people for strategic reasons. What I know is simply this. The colonel announces to the public to the community, to the media, that there's ADOT video that's been reviewed as part of the investigation. County attorney, ostensibly DPS, as an agent under Carpenter, says there's no such video. One says black, the other says white. Very simple. And then, when it comes to the issue of the shifting timeline on shooting number 4, Milstead says it happened between 8:22 and 8:27. There's nothing in the record to
Well,
support.
whatever he may have said is not evidence.
True, but it may impeach the investigation and the other witnesses.
I don't know that either yet. I seem to remember a director of a very big organization calling on ISIS juvenile, JV team. Don't know where he got the information, but it's not relevant to the facts. So right now, I'm going to rule that your motion is premature. If you find through folks that you've interviewed that he is a witness, then we can revisit the issue. But based upon everything I've heard and read so far, he has no recipient information related to this case. So the motion for a deposition at this time is denied.
Without prejudice.
Without prejudice. There was a motion to modify release conditions to afford the state an opportunity to review that motion. The court will hear that motion next week. Also, there was a motion to appoint counsel. The court will afford the state an opportunity to review that motion and hear that next week. Did you guys set a date for next week?
Your Honor, we actually picked April 26th at 9:30.
That's okay, Mr. Lamb?
I think that's the first date that all parties are available, Judge.
All right. And then affirming the April 29th hearing, we'll do, that's on the, both the DPS and the FBI texts,
Yes, Judge.
right?
Yes, Your Honor.
And if the parties, to prepare me for that hearing, if you send me anything under seal, any of the exhibits, I've reviewed them. If that will make it more efficient, I'll be happy to do that. Anything else for today, Ms. So we'll set that at 8:30 on the 26th. 9:30.
Sorry.
9:30. And on the 26th, that's at 8:30?
So the 26th is 9:30, Your Honor, and the 29th is 1:30.
Okay. Thank you. So 9:30 on the 26th, and that will be on the motion for counsel and the motion modified these conditions. Anything else, Ms. Losico?
Not from the state, thank you.
Mr. Lamb?
No, sir, thank you.
Mr. Farragut, anything else?
No, thank you, Your Honor.
Thank you, we're adjourned. Maybe upstairs or...